We have the quorum, and let's resume our hearing on Chapter 4 of Audit Report number 84. So for Part 3, 2 members are waiting to speak on Part 3, Mr. Lok Chung Hong and Ms. Eunice Yong. I give the floor to Mr. Michael Lok. I have a question about the figures. It's in paragraph 3.4a. 29,000 statutory notices. Those were withdrawn. How many were withdrawn because of the buildings were to be demolished? So I need the figures. Now 26,000 notices were not complied with, and what we did with them. We all think we should move fast in enforcing the law. The principle is sound. But I'm trying to approach the matter from a different perspective. Mandatory windows inspection is about getting to take safety seriously. We want to minimize accidents. More prosecutions isn't necessarily better. Many buildings involved were 3 new buildings. The building owners involved, even when we're talking about private flats, may involve owners with limited means. Those may be seniors relying on their limited savings, or they may be owners who don't know what they're supposed to do. So enforcement of the law should be a balancing act. We also have to bear in mind that prosecuting someone comes with a cost, and that's a form of social cost. So issuing warning letters and prosecution should not be the first response. Otherwise, you will see a public backlash. Now, there were outstanding statutory notices outstanding for a long time. Some were 3 new buildings. What's the share of 3 new buildings for such outstanding notices? And while these notices were outstanding, has the department called them to find out how they were doing, apart from just issuing warning letters? Those households may be Doubleton elderly households. Those seniors may struggle to make sense of the letters sent to them from the government. So have we done home visits? So have we sent someone to talk to them about the invoice notices? Have we told them about the legal risks? Have we told them about the risk of prosecution if they fail to comply with the notices? Have we tried to talk to them nicely about the notices? And then for 3 new buildings, what steps were taken? And then for some buildings, building owners may disagree over the sharing of costs. How has the government coordinated the work in such cases? So some questions and some comments from the member. Director. So we first issue the mandatory windows or buildings inspection notices. We get calls from people. When we're asked to visit those buildings, we send people there. If our officers can make time for it, we get our consultants to visit those owners. In many cases, building owners indicated difficulties. They cited ill health or financial difficulties. Sometimes if the owners struggle to make sense of what they were expected to do. Now we resorted to the more mandatory measures because the owners showed no intention of complying with the notices. We laid the facts on the table before those owners and get them to act. Now, for 3 new buildings, I don't have the figures at hand about the share of 3 new buildings among those outstanding cases. I mentioned persuading owners and offering technical assistance. We have been doing that. At residents' meetings, we also send officers to attend them. Now, we also have Operation Building Bright 2.0. For Category 2 buildings, under OBB 2.0, we also select buildings that are at risk with owners with limited means. And for OBB, we cover both mandatory building inspection and mandatory windows inspection. Mr. Locke. Now, first, I would like the figures about the share of 3 new buildings among non-compliant cases. This figure will be helpful. And I heard there's 3-step approach. First, we talk to them. Second, we issue the letter. And 3, prosecution. That's good. That shows empathy. So will we take a lead from the playbook of the Fire Services Department? So this means the government steps in by offering default works, and then we recover the fees from the owners. That can save the work for building owners in finding professionals. So will we adopt the FSD's practice? If so, when will we implement that? If we reject that, why not? Now, I also have some further questions about the figures. Paragraph 3.6 show that from 2017 to 2024, 445 cases of fallen windows were recorded. Among them, 131 involved buildings that received the notices beforehand. But then for 25 cases, roughly 20% or so, the notices were still outstanding before the windows fell. So my question is, has the BD found out that for the 445 fallen window incidents, have we found out the causes? Do we have a breakdown? So were those cases due to the rust on the window components? Were those cases of misuse of windows or other factors? Now, for the 314 cases involving no windows inspection, how many of them had to do with buildings under Mechanism A, and how many fell under Mechanism B under Chapter 2 of the audit report? Mr. Ho, or rather Secretary. Now, on the breakdown and follow-up for the 445 cases, the BD can take that question. Now, I want to address the policy question about default works. Default works are not offered as an option to building owners. We don't just offer default works as an option to owners, because we stress that it is the responsibility of building owners to arrange inspection and repairs. But then, there are cases where we think further attempts to urge building owners to act will be futile, and then the buildings are at risk. In those cases, we resort to default works. This is the approach taken by not just the Fire Services Department, but also the Buildings Department. But default works are not a standing option for owners. Mr. Ho, for the 445 cases of fallen windows, we are going through the detailed analysis. From what we know now, 10 such cases were buildings outside the scope of mandatory windows inspection. Those may be buildings of 3 stories or fewer. And as for the other cases, we have looked at them. 85% of those 445 cases involved buildings aged over 30. I just mentioned 10 buildings that were outside the scope of MWIS. Now we can categorize the cases into 2 groups. 134 buildings were selected as target buildings for mandatory windows inspection. And then you had 295 cases that were not selected for MWIS. Now, as for the 134 buildings selected for inspection, there were 140 incidents. We selected those buildings for windows inspection, and they involved 134 buildings. The member's question was how many fell under mechanism A. 70 were under mechanism A, and 64 were under mechanism B. We will continue with the detailed analysis. Now, 140 incidents involving 134 buildings. For these buildings, the follow-up work on their MWIS notices are underway. Many such buildings have already complied with the notices. "108 buildings have already complied with the notices out of the 134 buildings. As for the other buildings, they are at different stages of prosecution. Some buildings voluntarily complied with the requirement. For others, we issued warning letters. For 3 buildings, they are being demolished for redevelopment." Mr. Lok. Now, for 106 incidents of fallen windows, those buildings have followed with the notices. How come windows fell even after the inspection? Have we looked into why? So how long did the windows fall after the inspection? Was it 1 year apart? Did the contractors did a sloppy job in inspecting the windows? So what caused the windows to fall after the inspection? So that's my question, Mr. Ho. Now for the 106 cases, out of them, 32 buildings involved statutory notices complied with more than 5 years before. So there was an earlier repair. And as for the remaining 60 cases, we investigated every single case. During the investigation, we found 4 cases. These 4 cases involved deficient work done by qualified persons. So we considered prosecution for those 4 cases. For 2 such cases, prosecution succeeded. But as for the other 2 cases, there was not enough evidence, so prosecution could not proceed. As for the other cases, the remaining cases, we could not find enough evidence showing the qualified persons did a poor job. But we fixed those windows.
I hope that after the inspection is conducted, you will still look into the status of the windows to make sure that they will not fall again. Lastly, while 25 of the cases where notices have not been complied with have their windows fallen. Will the department charge the relevant persons with objects falling from height apart from non-compliant with notices? Do you have any prosecution figures? Director. For the remaining 5 cases, 1 of the case has been complied with and 1 is undergoing repair. 1 is being prosecuted. As for the other two, we have issued fixed penalty notices to them. We will follow up on the case. Buildings Department have not invoked the buildings ordinance to prosecute the owners in these cases. For offenses of falling object from height, the police is responsible for that. Thank you, Ms. Eunice Young. Thank you, Chairman. Many members have asked about 3.4, 3.5 to 26,000 notices have not been complied with. 11,000 notices have remained outstanding for more than 3 years and up to 11 years. The administration explained that one case has been outstanding for so long because the file has been mislocated. How come so many notices have remained outstanding? Is it because the owners missed the notices? Is it because of human mistakes? I'd like to know the reasons behind all these outstanding notices. Director. For Table 2, we have prosecuted the case with the longest outstanding notice. I'm not asking about the longest case. You said that you have mislocated the file and you already prosecuted them. There were 11,000 or so of cases that have remained outstanding for more than 3 years. We're talking about 3 to 10 years. I'm not referring to the most extreme case. I'd like to know what went wrong with your internal mechanism. I know what your way forward is. I know that you will make improvement, but I just want to know why you didn't handle these outstanding cases for such a long time. Is it because manual labor is involved? Is it because you use physical files and papers? I'd like to know what went wrong. Director. To put it simply, after sending the mandatory window inspection notices, the buildings department will reach out to the owner. In the process, the owner may make inquiries. They may need technical support from the department. We try to persuade them to follow or comply with the notices, and this takes time. Very often, the owners show that they want to comply with the notice, and for these owners, we don't issue them with warning letters. And sometimes owners only indicate that they want to comply with the notice after we've issued a warning letter to them. If we confirm that the owners have no intention to comply with the notice, we may issue fixed penalty notices. That will affect the progress of our follow-up action. Ms. Young, if there's so much interaction between the department and the owners, I believe that you will be able to produce evidence. There should have been 20 to 30 letters between you and the owners for each and every case. I wonder if it's because you sent so many emails back and forth, that is why you don't have enough manpower to handle these paperworks. The owners may be old, you may not have enough manpower to handle the cases. That's why the notices have not been complied with. Ms. Khan just asked about the workflow. You said that you have statutory notice. If they don't comply with them, you issue them with fixed penalty notice, and then you may prosecute them. even after the fixed penalty notices have been issued, 40% of the owners issued with these notices did not make the payment. If you'd have constant communication with them, then you would have known that whether they actually intend to make the payment or comply with the notices. I think that you are just passing the buck on to the people. By claiming that you have been communicating with the owners. However, I fail to see any emails or correspondence between you and the owners. I'm not convinced. For the extreme case, the notices have been outstanding for 11 years, but in general, the notices remain outstanding for 3 to 10 years. I don't think that's acceptable. How come the government would spend 10 years to communicate with the owners? No one would be convinced by your excuse. With such facts tabled before us, you still explain to us that you have communicated with the owners. You claim that you're going to adopt technology. The entire workflow is flawed. After the fixed penalty notices has not been paid, then you will issue warning letters and you may prosecute them. Each step of your workflow is flawed. If the administration still don't know why they have so many outstanding notices, I don't think that we can improve the mechanism. If you have a mechanism, then you don't have to, quote unquote, continue to communicate with them. You just ask the owners to talk to the court. If the owner don't make the payment, we may jail you, for example. We should trust the court. So I wonder if the administration can give us some evidence. Including the correspondence between you and the owners. I fail to understand the response and explanation given by the administration. I think that's an excuse rather than an explanation. The director explained earlier that by communication, well, actually, I've come across similar cases when I was a district councillor. So when the owners received the notice, they sometimes didn't know how to comply with them. If they didn't respond, then the department will order them to comply with the notice. However, if the owners respond to the department, then the department would not take follow-up action. There were often many back and forths between the owners and the department. The owners have many excuses or reasons as to why they could not comply with the notices instantly. Perhaps they are renovating their apartment. Can the administration further explain? Although I know that you are going to set a time limit of, say, 6 months for the owners to comply with, can you explain more about the circumstances or situations that you had come across with previously? Director, Mr. Ho. Sometimes we talked on the phone, sometimes we sent letters to the owners. We have our manpower constraints. We did take follow-up action proactively. Some owners write to us and we have to reply them by sending them a letter. But is this the case for all of the owners? That's not. Sometimes we talk on the phone. What members were trying to say is that many notices have remained outstanding for quite a long period of time. I understand that some owners want to delay the compliance, but some windows may pose risk to the public. That's why I believe that we have to strike a balance between the needs of the people and public safety. Ms. Young. Thank you, Chairman. I'm not trying to make things particularly difficult for the government. I know that you do have a manpower constraint. You need to answer people's inquiries. Mr. Look suggested that you knock on the doors of the people to check up on them. If the entire building is subject to window inspection, well, you have sent us your minutes of your meetings, and you're going to establish a new panel for 2025. Many members are district councilors, and there are 2 ex-official members from buildings department. I don't see any members from the community care teams. If a building has been selected for inspections and has been issued with statutory notices, you should perhaps send community care team members to assist you. I know that community care teams are allocated with resources to carry out these duties. For example, these teams are allocated with resources to, say, process food waste or install these facilities to process food waste in various districts. In the Eastern District, Yaoqing District, these are buildings with many dilapidated buildings that are subject to window inspection notices. Will you ask the community care team to help you in reminding the owners of the buildings that have been issued with MBIS or MBIS notices? You should ask the community care team members to help you to enhance the response rate and compliance rate. Members have been asking why you replied to owners' inquiries so late, and how come there are so many outstanding notices. You should leverage on the community care teams. Secretary. Currently, through the Urban Renewal Authority, we enter people's apartment to explain to them the MWITs and MBITs. URA staff act on behalf of the government to provide technical support to owners regarding these 2 schemes. And the Home Affairs Department, with regards to 3 new buildings, they do have a team of colleagues to handle the relevant inspections. Can we leverage on the community care teams to help us in the promotion and publicity of these 2 schemes? We work with the Home and Youth Affairs Bureau. We don't want the community care teams to work on explaining our policies unless we have pamphlets available for them to distribute. It would be rather difficult for us to ask the community care team to explain to members of the public our policies. We don't want to burden them with such a task because they have other duties to carry out. However, if we do have pamphlets available, we may assign them with such a light tasks. Member asked why there are so many outstanding statutory notices. Well, first, it has to do with whether the department have set a time limit for each step under the workflow. Some indicators have only been formulated last year. For example, when should we issue a fixed penalty notice after the statutory notice have been issued? Now we also have an indicator as to when we should instigate prosecution after the fixed penalty notice has been issued. Now we're working on putting in place indicators. Second, I used to be a director of a department, not buildings department. Colleagues have their own discretion. Sometimes we have time limits set in place, but some colleagues may choose to be more sympathetic. That's a judgment issue. I think that the department should step up communication with their staff. Third, the Policy Bureau will try to expedite the amendment of the buildings ordinance. If the penalty level is not high enough, then owners will not be incentivized to comply with the notices. So these are the areas that we should work on. Ms. Yong. I thank the Secretary for explaining about the duties of the community care team. I know that other departments have allocated resources to various groups and organizations to explain to members of the public various policies of the government, such as environment-related policies. We do have the district council is offering mediation services to the people. I hope that the administration will leverage more on district and local organizations because they have a strong network in the community. And I hope that the administration will make good use of their resources. On the point about prosecution, as I mentioned, the department has not instigated that many prosecutions. They have a fast-track prosecution team. It seems that the team didn't really instigate prosecution that speedily. So I wonder if the fast-track prosecution team will initiate more prosecutions in the future, and will the team help in recovering the outstanding fixed penalty notices? Director, we will definitely step up prosecution in 2024. 2,500 prosecutions have been instigated for MBITs, 300 for MWITs. Last year, we asked the court to allocate more slots to us. They said that they can allocate 250 more slots to us last year. For us to achieve such a number, we need more referrals. No other question. Thank you, Chairman. Ms. Khan.
Thank you, Chairman. We have limited time today. Well, actually, I have created certain timelines and charts regarding the questions that we have asked already. This is a timeline from the issuance of statutory notice all the way to prosecution. From issuance of warning letter to prosecution, since July 2024, you have added a time limit of 6 months. when a 6 months period is due, you need to issue the fixed penalty notice. How are the figures since July 2024? If you don't have the figures on hand, please submit it afterwards in written form. Director Ho, we will supplement in written form afterwards. After setting this time limit of issuing fixed penalty notice, I want to understand the compliance status. Second, I want you to analyze the 445 cases. If you did not further divide them according to different situations, please do so, because that is how you maximize the effect of this audit report. If there are 295 of them that are not included in the mechanism out of the 445, then how do you review your mechanism? Out of the 445, if there are 131 cases that are non-compliant, even if they are included in the mechanism, what are the further information that you can find? When I look at the chart, after issuing the statutory notice, there are still a number of them that are still not fully investigating. 88 of them are still failed to be fully investigated. I think you need to do more analysis so that you can have some takeaways from the figures. That's how you can further improve yourself. If that is the analysis that you are doing, please submit it to us. This is my second requirement. Third, regarding the common parts, well, especially for the 3 new buildings, Director has mentioned that this will be your future focus. In the statistics that we have on hand, we also noticed that the non-compliance rate of the common areas is up to 27%. As for the individual premises owned by the individual, is only 4% of non-compliant. Out of the 27%, do you have the authority to conduct default work? I know this is not an option that you offered to the citizens. However, if you are being empowered by, I want to see if you are being empowered by the ordinance already. If so, then will you focus on the 3 new buildings? And afterwards, you will be recollecting the money from the buildings. How would you deal with the higher risk that are being posed by the 3 new buildings? We can provide you with the analysis afterwards. As for the default work, we are being empowered to do so, and this is what we are already doing. Usually, it is through the version 2.0 of the renewal of buildings. When we do the inspections of building, we will also conduct windows inspections. Will you put more focus on the 3 new buildings? Even if you are empowered to do so, you still need to find your areas of focus. What are your future plans, Director? We are already highlighting the 3 new buildings because they cannot organize themselves to comply with MWIS or MBIS. Ms. Ken? Finally, I want to look into the figures of the issuance of warning letter and the fixed penalty notice. Are we being stringent to them? If we look at table 4 on page 25, well, number of non-compliant statutory notice with warning letters issued out of the 26,000, there are 352 that have not issued with warning letters. That means 85 of them are not being penalized. It is about 27.5 million of the public coffers. Because this is people's lives that we are talking about. And it is also unfair to those who are compliant. If you issue them with FPM, or if there are people who are already complying the notices before reaching the stage of FPM, it will be unfair to those who are compliant if you do not tackle with them. If we look at big letter B, the total number is only 3,320, so it is not a huge figure. With FPN issued, I'm not sure if I understood it correctly. Can the Audit Commission get back to me on this? Commissioner, it's accurate. In other words, you only issue very few FPN. So you are not being tough on the citizens. I think 85% of them were not being followed up, and there is no issuance of FPN. Only 15% have been issued with FPN. This is what I would like to point out. Director Ho? As mentioned, there will be some strengthenings of our actions, and we also have some internal guidelines on the issuance of FPNs. Well, we have a working group focusing on the time-lapse cases, and there are also guidelines helping us to step up our actions. Ms. Khan? I hope that when we look at the figure from July 2024, I suppose that the case are being tackled according to the 6-month time period. I hope that those figures will be supplemented after the meeting. Any further questions regarding 2.3? Yes, Vice Chair. I have some follow-up questions. A question of clarifications. I understand that we are now reviewing of new provisions. If there are fallen window cases causing injuries and fatalities, perhaps there will be some step-up offences. In the Summary Offences Ordinance, there is already a certain provision talking about the falling object. In those cases, the owners or the person in charge of the renovations work needs to be held accountable for criminal offences. I would like to clarify on this point. Director Ho, that is how we understood it. Because that particular ordinance is not being enforced by BD, we will try to clarify it about the execution from the police force. Is there any records of the police prosecution because they are indirectly enforcing it for you? I know that there is no such tools at this moment. Just now, many members are focusing on the 445 fallen window incidents. This is actually one of our policy objectives because we want to prevent fatality or injury cases from happening. Before such tools are in place, do you have any measures in place, or do you need to rely on the police for law enforcement so that the owners will not be that stubborn? You can issue warning letters or FPN or even instigate prosecution. Are these steps being carried out? Director Ho? Generally speaking, certain fallen window cases are being referred to us by the police. They will be considering the law enforcement according to the Summary Criminal Offences Ordinance. To strike a balance, we will also look into the building ordinances and see how can we follow up by the issuance of different letters that we have. These are the tools that we have. If they instigate prosecution, they may or may not inform us. As explained by the Deputy Director, sometimes you are being informed by the police about fallen window incidents. Why don't you follow up? Why don't you try to understand what are they doing to help you? Why are you so passive? Why didn't you initiate such actions from the police? Secretary, I would like to supplement to it. The Summary Offence Ordinance, as implied, it is a streamlined procedures, so the penalties are rather lenient. If we want to have a deterrent effect, I believe that the Summary Offence Ordinance is not sufficient. But of course, we need to make use of everything available to us. In the past, I trust that the BD did not follow up with the police force because we already know that such enforcement will not carry sufficient deterrent effect. Recently, we have already requested the BD to set up a communication mechanism with the police force. The BD has expressed that even if there is a fallen window incident, they are only aware of that through the media, and they don't know specifically which unit in that building is involved. They should have better communications with the police. Let's say when the police is going to the building, they have to involve the BD so that they can look for incidents together. Such measures will be helpful to us in the future. If we are looking for a deterrent effect, I think we can't rely on the summary offences. Therefore, we will try to speed up our ordinance amendments. Yes, in Cap 228 in 4 big letter B, it will be fined with 6 months of imprisonment and also penalty of level 3. You can communicate with them over phone, or as Ms. Young has said, some cases have been delaying for up to 10 years. So what are the steps that have been taken in this period of time? Surely we understand the difficulties that you have, because sometimes we will receive complaints about you being too heavy-handed. Sometimes you will be causing a lot of nuisance on them by requiring them to inspect on the unauthorized structures or windows. However, when we look at the figures here, we were shocked. When we look at the issuance of warning, LPN, prosecution, second prosecutions, I think that has never been done. There are already so many steps in place supporting you to reach your goal, because your goal is to prevent injuries and fatality. Objectively speaking, it is far from ideal. If you don't want to cause any harassment on the citizens' part, if you want to give them a certain room or space to handle it flexibly, of course I can understand that. However, if the whole department is being a slippage in following the ordinance, well, I don't want to blame you for avoiding law enforcement knowingly. The reality is that you already have many tools on your hand, but there are slippage in your execution. In 2020, when I look at the previous report on this particular topic, I think the areas of concerns are almost exactly the same, including the non-compliance of the guidelines of the selection panel, and they have failed to notify the panel on non-compliant case. It seems that history is repeating himself. If people fail to comply with ambers, you can even cancel out the lease. I think you are accountable to step up your enforcement, because if you fail to do so, it will be unfair to those who are compliant, as Ms. Khan said. If we see that you are being slippage in enforcing the ordinance, you need to be held accountable. How would you respond to that, Director Ho? For the non-compliant case, in the previous month, there are already an increase of 70%. 93% of cases have been issued with warning letters. For the remaining ones, they have responded to us in a positive manner. We keep following up on these cases. For some cases, we will issue FPN. A year ago, there is no time limit. Therefore, last year we have put in place a 6-month time limit for such actions. For the referral of prosecution, we have already put time limits in place. We will continue to step up our actions. Well, in our interactions with the citizens, when we try to carry out audits, we do experience tensions. However, as we review and revise the guidelines, there will be some clear time limits, and I believe that we will be able to step up the actions better. I know that this is not just sole responsibility of the director or secretary, but if it is the departments that fails to be effective, then you are responsible as well. In the past 12 years, this has been the situation for 12 years. Why do you wait till last year to put in place some time limits? You don't even have time limits for the referral of prosecution. Are there issues with your execution over the years, Director Ho? In the past, we focused on persuading the owners and to issue warning letters, and we have looked into the effectiveness of warning letters. Over 70% of our compliance rate is spotted. Therefore, we have an overall 96% of compliance. It is because in the mechanism we have warning letters as one of our tools. But of course, there will be even more interactions after the issuance of warning letters because some tend to be more willing to comply. Before last year, we don't have a clear time limit of the issuance of FPM, but now we have put such limit in place. And that is how we try to step up our actions to increase the compliance rate. In his opening speech, the director has given some figures. In 1997, 98 and 24, it is 90 and 78 cases respectively, which is showing a downward trend. So you have given us figures of 2017, 19 and 24. Why are you singling out these 3 years to prove a downward trend? Is it how you try to show us that you are already satisfied with such trend, and that is why you are just going to let go of this report? I can provide you with the figures here. In 2017 is 90 cases, 2018 65, 2019 78 cases, 2020 47, 2021 40. 2022, 32 cases. 2023, 50 cases. 2024, 43 cases. So the total is 445. Well, I did not give you all the yearly figures in my opening speech because I don't want to burden you with a long speech. Well, in 2023, this 50 cases is slightly out of the trend. I think your stand is acceptable. There is a downward trend. I can confirm that. In his response, the director has also mentioned something like this. I'm not sure if I heard you correctly. You said that that is a bottleneck in court proceedings. In the first, it's just 2005, but now it has increased by 300, so it's 2,800. And recently, you have further increased by another 250. Did I hear you correctly?
Director, correct. Our goal last year was 2,500 prosecutions for mandatory building inspection and 300 prosecutions for mandatory windows inspection. Sorry, 250 for windows inspection. Last year, we tried to secure more prosecutions from the court. The court agreed to an increase of 250 slots. So overall, for 2025, our goal is to secure 2,700 prosecutions for buildings inspection and 300 for windows inspection. So these are prosecutions instead of issuing fixed penalty notices. Sorry, Chairman, for bypassing you. I got confused. The court may be short of judges, so they get a bigger and bigger backlog. But I rarely came across this concept of a quota with cases, court cases. So how come we have this quota? So how come judges can give you a quota? Director, this is not a quota. We applied for summonses from the court. We had to go through the court system. Once we reach a certain number, the court does not allow us to apply for more summonses. So we found out from the court there was a limit on this number. So we talked to the court to ask for more summonses. We talked to the court last year, so we managed to secure an extra 250 summonses last year. So are there limits? Is it an online system that prevents you from applying for it, or does the court fix a quota? Does the court ask the buildings department not to work too hard? Has this point been explained to the Audit Commission? I find this puzzling. If this is the case, we should ask the judiciary to come here to join us at the hearing and explain themselves. Director. So can we provide a written reply or explain this at the next meeting? The next meeting may be 2 p.m. or maybe we won't have the next meeting, so you don't have an answer at hand. So a written reply, okay. So I think the director's point is that you have to go to the court to obtain the summonses. And then there are court slots. So maybe the court told the BD not to issue too many summonses as well, but you have to find out more about this. I don't think there are such restrictions on slots. If the courts cannot get to all the summonses, they get to those summonses later. Otherwise, that would be very unfair to the BD. We ask the BD to enforce the law. We blame the BD for acting too slowly. We have the fast-track prosecution team. FPNs have to be noticed, and then there are warning letters, and then there is prosecution, and there are second prosecutions. When you have the bottleneck at the judiciary, we will be unfair to the BD by asking them to act and blaming them for acting not fast enough. We issue fixed penalty notices for illegal parking. For illegal parking that lasts just a minute, but then we allow a department to not enforce the law for 10 years. So we have to find out whether there is really this problem with the judiciary, real or imaginary. This is a shocking revelation. Has the BD explained this problem to the Audit Commission? Director. Now on the cap, I will offer a written reply. Have you talked to the Director of Audit about this bottleneck on the judiciary side? From my understanding, no. Secretary. From what I know, we're not talking about the quota. When the buildings department wants to apply for summonses, the question is whether there is room for processing such summonses. It's an operational matter. I can say with confidence this is not a quota system. Maybe the BD can offer a written submission to clarify the point. So I will leave the point for now, but maybe the Audit Commission has something to say. Director of Audit, Professor Nelson Lam. Thank you. I just came across this point for the first time today. So I will leave the point here. I will wait for the reply, to be fair to the BD. Ms. Carmen Khan. Thank you. I want to follow up on Mr. Porter's question. The Bureau and the BD should clarify the point right away. The Audit Commission just said they came across this idea for the first time, and we should dig deeper into this matter. We should find out. Now, based on figures from the Audit Commission, for the 3,320 FPNs, 2,792 were not referred to the fast-track prosecution team. And then you have the goal for 300 prosecutions for Windows inspection in 2025. It will take you 9 years to work through all those cases. So we need a written reply to clarify the matter so that we get this right. Director noted. Yes, we will provide the reply. So if there are no other questions from part 3, now Mr. Louis Long. Please move on. Chairman, let's move on to part 4, and this has to do with monitoring qualified persons and other issues. Paragraph 4.3 says that under the Building Inspection and Repair Regulation Cap 123P, a QP or qualified person should submit the following documents to the Buildings Department within the specified time frame under MWIS. And then we have paragraph 4.7. So with the support of the trade starting from April 2018, the Buildings Department stopped requiring this notification of appointment of QP. And then the BD or the Bureau will review the feasibility of the relevant arrangements. So with the trade support, the BD can depart from the ordinance. I want to avoid the term, but isn't that a precedent of departure from the law? Secretary. Allowing departure in a specific case would amount to not following the law. But as an overall arrangement, waiving this requirement to notify the BD amounts to streamlining procedures. When we adopt this practice across the board, I take that as the BD granting an exemption. Indeed, there is uncertainty given what's written in the law. So in our legislative amendment, we will incorporate this streamlined arrangement into the bill. Mr. Louis Leung. I'm all for streamlining procedures. That's something I have been calling for in the industry myself. But then starting from April 2018, this arrangement has been in place. We should amend the ordinance at speed so that the legislative requirement matches the streamlined arrangement. That will be the better way forward. The Bureau, I believe this has been noted. Mr. Louis Leung. So in the review of the buildings ordinance, this arrangement will be incorporated. Secretary. So we have stated openly that in the first half of next year, we will submit the amendment bill to the buildings ordinance. In that amendment bill, we will incorporate the point about paragraph 4.3. So we will enshrine this streamlined arrangement into the bill. Now, next point, Mr. Lewis Long, 4.17. So Audit looked into the follow-up actions of over 100 cases of fallen windows, and then for the 14 such cases, no follow-up action was taken because after a site visit, BD officers could not find the specific units involved in the cases of fallen windows, and then for some cases of fallen windows, the BD only learned about the cases through media reports. So my question is, how come that after a site visit, BD officers could not find the exact unit involved in the 14 cases of fallen windows? Even if the BD only learned about the cases through media reports, even if those cases were referred or alerted by the police to the BD, windows fell from those units. I find it mind-boggling that how the BD officers could not pinpoint the units involved in those cases. Director. We learned about those cases through 3 channels. 1, reports from members of the public. 2, alerts from the police. And 3, an internet search of fallen window incidents every 6 months. So for the 3rd channel, meaning an internet search of cases that happened in the past 6 months, there's a lag between the incident and the point we did the search. We did the search every 6 months. So by the time we visited the premises, the fallen window had been fixed. So our officers could not pinpoint the specific unit. And in some cases, all that we got was the street name, and then because of this lag between the incident and our visit, we could not find the specific unit. So those are the reasons. Sorry, I want to clarify a point. You mentioned 3 channels, one of them being police alerts, and there's another report from the public, and then 3, you do an internet search every 6 months. How do you search for the information? How do you look for the information every 6 months online? Do you go through online posts, commentaries? So we do a keyword search. So we search keywords like fallen window incidents. We'll use text strings to search for the information. So those cases are separate from the cases from the report from the police and the public. How do you know those cases were for real? That's why we found out, we verified those cases. In some cases, we managed to find the addresses involved, but then in others, like the dozen of cases here, we could not find the address. Did your officers have to see a broken window before they start investigating? What would trigger an investigation? In those cases, we could not find the broken window, so we could not start the investigation. So your officers arrived on scene, they could not see the window, but you only heard about the case through the media. You did not know when the cases happened. And then you incorporated those cases into your report, and you tallied those cases as well. Mr. Lewis Long. Chairman, I share your response. So you saw something online. I struggle to see why you had to search for those cases online and then you sent an officer to the site. Isn't there a better way? Why not have a mechanism, which I believe you don't have at the point? Let's put in place a mechanism. If a building has recorded a case of fallen windows, let's make it mandatory for that building to report the matter to the buildings department. Maybe this warrants a legislative amendment, but a fallen window is a serious incident. Someone may get hurt or get killed. So in that case, the owner or occupier involved should have a duty to report the matter to the buildings department. That does not sound onerous. Do we have a mechanism? If not, will we consider amending the ordinance to put that mechanism in place? Secretary, policy-wise, there is no such mechanism in place. But in the upcoming legislative amendment, we will get to that. Now, from the audit report, we have learned things and we are considering whether we can incorporate something such as a notification mechanism into the upcoming legislative exercise. We cannot promise we will get to that because we have to be realistic as we consider the factors. The director mentioned several channels through which the BD learned about cases of fallen windows. So instead of doing an internet search every 6 months, the director is considering doing monitoring media reports in real time. Like what you had last year, an interior designer claimed they removed the structural wall of a building. So when we come across a media report of a fallen window, we follow up right away instead of waiting for 6 months. We can also step up communication with the police. In some cases of fallen windows, people file a police report, and then on the scene, the people may have removed the fallen windows already. So we have to make sure that the buildings department and the police talk to each other, and we are working on that. Mr. Lewis Long. The Secretary actually addressed the point I was going to come to. So let's not wait for 6 months before doing an internet search. By then, the evidence will be gone. So the Secretary just mentioned real-time monitoring of online information. That's good. And then the Secretary also anticipated my other question, and that is talking to the police. We need a mechanism for closer engagement between the BT and the police. A fallen window incident may first go to the police. If the police and the BD work in their respective silos, that will mean delays in follow-up actions and law enforcement. So I come to my last question for this part. Paragraph 4.31 through 4.33. The Buildings Department has this mobile app called WinSafe. Now I'm looking at table 13. This WinSafe app took more than $2.6 million in development. In 2023 to 24, more than $440,000 was spent on maintenance. But then the app was launched in 2022, and up to the end of 2024, cumulative download was only 13,000. registered users 3,900. There were only 1,026 quotation requests from people to qualified persons for quotations. So I looked at the estimates to the Finance Committee from the government. Back in 2016, the Buildings Department launched a mandatory building and window inspection toolkit. It was an app to tell the public about how those mandatory inspection schemes would work. And then from 2016 to 2024, overall download was only 25,000. And that app was removed in September 2024. I brought up all these details because my question goes like this. So when you make a decision on whether to develop a mobile app, why are you so restrictive in the function of a mobile app? You have an app that serves just one purpose. How can you get people to download the app? Will the BD consider developing a one-stop app? Can we have an app that's a one-stop shop, integrating all services of the BD, everything in one place? If you do that, you will get more people to download and use the app.
Director. Development of mobile application is a trend. By using these mobile applications, people would get the information that they need in a more speedy manner. Users will need to learn how to use these mobile applications. However, we developed this WinSafe mobile application because many windows were subject to inspection. We issued a large number of statutory notices. That's why we thought that we should develop a separate mobile application to meet the needs of the people and the owners. The growth of users for this application may be slow, but still there is a growth. Say, for example, in May, we already have 4,560 registered users with WinSafe. That's an increase from the figure that we reported last time. As we have many windows in the city, we think that is sustainable for us to maintain a separate mobile application. When we launch mobile applications for other services, and if they have to do with window inspection, we may combine or incorporate various functions into the same application. Thank you. Mr. Long. I've heard the director's explanation and their rationale. All I wanted to say is that if a mobile application only serves a single function, the usage rate would definitely be low. What I don't want to see is that the WinSafe mobile application will be removed from the App Store, just like the case with the mandatory inspection toolkit application. if the usage, well, if the number of downloads and the cumulative usage for the mobile application continue to be low, I hope that the administration will look into how they can promote it so that more people will use it. One of the ways is to integrate various mobile applications so that you can have an all-inclusive mobile application that cover all types of services offered by the buildings department. By that, I believe that the usage will be boosted. Thank you. Mr. Long, any other questions? No. Next, Mr. M. Wong. Thank you, Chairman. I have questions regarding paragraph 4.7, note 2. It is said that because there is mistakes in the submissions, that's why a delay of 1,807 days were seen after the completion of the prescribed inspection. The BD said that they only uncovered the problem when they cleared the backlog in 2024. How come the submissions made in 2019 were only audited in 2024? Director? Deputy Director? Yes, we've laid down the truth here. There were incorrect information in the forms, and they had to resubmit the form with correct information afterwards. And the form resubmitted was the correct one, and the delay lasted 1,807 days. So when they submitted the form in 2019, you didn't notice that there was incorrect information therein, and you only discovered the problem when you processed these papers in 2014. Director, that's true. Deputy Director. We receive over 50,000 forms every year. We do sample audit on these forms. Our mechanism is that we believe the form submitted and the information therein is true. When we do sample audit, we will look up the supporting document behind the forms. Because the notice number on the form was wrong, that's why we thought that the case was being complied with. When we followed up on a non-compliant case, the owner told me that they already hired a QP to inspect the window, and we discovered then that the QP actually put the wrong notice number on the other form, and that's why it took so long for us to follow up on the wrong information. So the notice number was filled by the QP or you? Well, the QP filled the notice number in the form. Mr. Wong. You said that you only discovered the mistake when you conducted the audit. So how many certificates did you check every year? Deputy Director, we don't have a KPI. As mentioned in the audit report, we have to process 500 certificates successfully. If the success rate is low, then we have to sample more cases. Our ultimate goal is to audit 500 cases successfully. Now I'd like to turn to 4.9, success rate in conducting audit checks. The BD already told us about their target. However, due to various reasons, for example, the owners being uncooperative, that's why the BD failed to conduct audits, and they have outsourced some of the works to solve the issue. Despite their efforts, the success rate is only 11 to 29%. That's under paragraph 4.10 of the report. So how can the BD raise their success rate? Director, first, we hope that the owners will allow us to enter their premises for site audit. We have amended the letter that we sent to the owners. We stressed in the letter that the owner must be cooperative, and that's only beneficial to them. By this, we hope to encourage them to allow us entry to their premises. And we are looking into amending our legislation to empower the building department to enter into the premises. If the owners don't cooperate, there may be consequences. We are looking into this. Mr. Wong, I'd like to clarify one point. So currently, you can only ask the owners to allow you to enter the premises. You don't have any statutory power to enter their apartments. Am I right, Director? Because we're talking about M-Woods here, and the owners have already conducted the inspection. They have already maintained and repaired the windows. They have already submitted the reports. So strictly speaking, the owners have already complied with the statutory requirements. If we don't have any suspicion, we shouldn't have the power to enter into their premises. I have a question regarding Table 9, Note 2. It is said that the longest case, which took 792 days or 2.2 years to complete, was due to mislocation of the subject file. What is this about? Director. Our colleague may place the file at the wrong location. We're going to upgrade our computer system to prevent the same from happening again. We're going to digitalize all of our data so that our records can be more accurate, and it will be then easier for us to retrieve information. Mr. Wong. So is it the case that you create a file for each and every case, and if you can't allocate the file, then you wouldn't be able to follow up on it? So you adopt this understatement approach. If the file look more old or damaged, then you may follow up on it quicker. Is that the approach that you adopt? Deputy Director will take the question. Thank you. In our following up of non-compliant case, we're going to generate a report from our computer system. We try to look at how many outstanding cases we have, and we're going to prompt our colleagues so that they will follow up on those. For colleagues, well, some colleagues may not be able to identify the file. Actually, the computer system will generate prompts to colleagues, and after the prompt's been send to the colleagues, they will try to look up the file from the shelf. So I'd like to know where you put the file, because you shouldn't be able to bring the file back home. It should be in your office. If the computer system prompts you to follow on the case, how come you couldn't be able to identify the file? If IRD has the same system, then many taxpayers wouldn't have to file their taxes or pay their taxes. I wonder where the file end up in. Deputy Director, I don't have the information at hand. As far as I understand, there are many parts to a building and they may come under different files. We can try to look up this case. Is the file with a different team? We will supplement with further information later on. Thank you, Mr. Wong. I'd like to ask about 4.19. The percentage of invoice submissions by electronic means has increased from 2% in 2020 to 8% in 2024. Despite the increase to 8%, the number is still low. It seems that the many problems that we discussed are about manual errors. How can we lower the number of mistakes made by your colleagues? Director, we have already issued a circular to qualified persons to remind them of the electronic submission system that we have. In the long run, we're going to improve our electronic forms and upgrade our computer system. We now try to improve our process. If the data that they enter is wrong, they shouldn't be able to submit the form successfully. If the data that they enter is wrong, say if the date format is wrong, then the form should not be able to be submitted. If the date of inspection is later than the submission date, for example, then they wouldn't be able to file the form with the system. With such a function, it will be easier for us to monitor the information. Some qualified persons may still prefer physical forms. We may try to use a computer to scan the physical form and digitalize them so that the computer can analyze these data and upload them onto our system automatically. Mr. Wong. According to the report, it is said that the buildings department has set up a designated email address to receive submissions in electronic format, and they also have an electronic form submission system. You said that 8% of submissions were made by electronic means. That cover the submissions via email and also the submission system. Is that right? Director, yes. Mr. Wong. So as far as you understand, how many submissions were made via email address? Because if they submit the forms via email, then you cannot conduct data integrity check. I don't really know how to put what the Chinese of data integrity check is. My apologies, Chairman. You wouldn't be able to conduct such a check with email submission. I don't have information at hand. Deputy Director.
實你見有地
Mr. Wong? Well, it means that after receiving it through email, you still have to input it by hand. Is this accurate? Yes, it's accurate. Mr. Wong, do you have any incentives for the to encourage the QP to make use of the electronic form submission system? For instance, some government departments set out deadlines of submission. If they choose to submit it electronically, the deadline can be postponed. These are what I meant by incentives. If you just encourage, hope, or glad to see, well, if the sector is self-disciplined, then surely they will do it. However, how can you encourage the 18,000 QP to rely on the electronic means? We have already heard about your mistakes. So what are the incentives that you want to roll out to encourage them? Director, first of all, we have to make the system convenient to them. And we will also conduct different briefing sections. We will also notify and encourage them to make use of it through circulars. In long run, through publicity and encouragement, perhaps they will submit it electronically, and in the future we will consider if they submit it in paper form. We will also put in place certain requirements because we can ask them to submit certain forms in electronic forms. Mr. Wong, I want to follow up the 4.7b paragraph. After submitting in 2019, then they will take it as compliant. They only find it during audit checks. According to the paper, it said that the BD in 2024, when they tried to take care of the outstanding cases, they discovered these issues and asked them to resubmit the certificates. So it is being found when you do audit checks, or as stipulated here, you discover it when you're trying to clear the outstanding cases. Deputy Director, for this particular case, it is being spotted when we try to clear the outstanding cases. But just then you said it is covered during audit checks and to resubmit and to change the record. What kind of case is that? Let me clarify. What I meant is that we will not immediately check it whenever we receive a form. I want to explain about the late discovery. One of the way to discover it is because of the audit check. Because we have the mechanism in place, it will not be notified. It will not be noticed after such a long period of time. So this particular case is being discovered when we try to settle the outstanding cases. What I try to clarify is that we will have a audit check mechanism. We don't check all the submitted form automatically. I don't have any further questions. Ms. Carmen Khan. Thank you, Chair. This section is about the monitoring of qualified persons and other issues. Therefore, we have to understand the role and responsibilities of these QPs. In 4.2, 4.3, there have been an outline of the roles. In paragraph 4.7, the administration mentioned that when they did audit check of the figures, there are over 20,000 cases needs to submit investigation certificates, and some of them are late. 10% of them were late. There are 1,977. They are overdue for 14 days or up to 5 years. These QPs failed to fulfill their duty. And it is showing us how do you monitor the qualified persons according to the ordinance if they are late in the submission. Chair, one scenario is that the qualified persons have investigated it and no actions needs to be done. Then they issue a certificate. After investigation, if they discover that there needs to be repaired, then they need to issue a report. So it is up to the QP. There is a 40 days of time period. If they are late, what are the penalties? Director, for the late submission, Normally, we will issue warning letters. In case of non-compliance, and in case of multiple non-compliance, we will consider disciplinary actions. It is not an offense. It is not an offense. Ms. Khan, I want you to submit a related document. In the 8-year scope of this audit, or at least from 2022 to 24, a period of 3 years, are there any QPs who are late in the submissions? How many of them have received warning letters? After receiving warning letters, how many of them are being removed from the list? Did you really exercise your monitoring of QP? Can you submit such documents afterwards? Yes. Paragraph 4.17. According to the audit submission, out of the 445 fallen window incidents, I think the approach of the Audit Commission is very targeted. They want to see what they can discover out of the 445 cases. They discover that 131 of them has been served with MWI as statutory notices. 25 cases has remained not complied. So simple calculations, there are remaining 106 cases. The Audit Commission continued to dig further. Among them, 14 of them, according to the department, no follow-up actions could be taken. Do you have a notification system with the police force? Well, because nowadays we have a summary offense stipulating how actions shall be taken in case of fallen objects. So how are you collaborating with the police forces? You said that there are 14 cases that no follow-up actions could be taken. Why is that so? So 106 minus 14, 92 cases. Out of the 92 cases, 88 of them there are 92 cases that are being investigated by QP. Out of them, 88 of them has no available record. How do you take care of them? During investigation, our staff cannot find substantial evidence proving that QP is in violation of building ordinance. Therefore, as we prepare for this report, the record is rather simple. For the 4 cases that were mentioned, since we have discovered evidence, so we have put together a full report. We also instigate prosecution according to the investigation report. We have also improved our procedures. As suggested by the Audit Commission, throughout all fallen window incident, in the future we are going to deploy a template of investigation reports, so all the required information will be recorded. It will be more convenient for us to upload this information to our system for future analysis. I think it is very important for you to have a written record on those cases that you are not going to follow up, because you need to note the reasons why. It will be helpful to the secretary and director. Well, because this MWIS section is headed up by the deputy director. Well, when you need to evaluate his or her work, you need to have a record for the cases that you're not going to follow up. I welcome what you're doing now, because you are taking records of the follow-up cases. I still have 2 more questions. The first one is about your collaboration with the police. Every 6 months, we will look into different medias to spot out any fallen window incidents. In the future, we will have real-time monitoring. As for the police, in the past, the police will always alert us immediately. And we are also sending out a memo to the police asking for early alert in such cases so that we can conduct follow-up actions at the scene. We will have even closer collaboration with the police. In other words, we need to communicate with each other about our own enforcement actions. Well, the recent case in North Point, how do you collaborate? Are you alerted by the police, or you learned about this already? There is a fallen window incident on the 12th of May. We visited that site because we learned about it from the media, so we went to the site and conduct investigations. Investigation has been completed and we have found out why. Ms. Khan? Paragraph 4.16. It says that out of the 445 fallen window incidents, 387 cases were reported to BD. 58 cases were identified from the media. You discover them from the media for the purpose of selection mechanism B. How do you come up with the summary in 4.16, Director Ho? For the cases that were identified from the media, it is this scenario of the 6-month period that I mentioned just now. If it is being reported to me, then we have already followed up immediately. Well, because the media sometimes will report to us, in those cases, we will carry out immediate follow-up actions. Because we want to be more comprehensive in mechanism B, therefore, we have set a period of 6 months. We will look into the media after 6 months to see if there is any missing fallen window incident. Commissioner, anything to add? No. After identifying these 58 cases from the media, did you include them in mechanism B? Director Ho, yes. Correct, yes. So we need to rely on media coverage so that you can identify them. Looking into the future, I hope that you can have a better alert system either with the media or with the police. How are you going to establish that? Director Ho? With regard to these cases, we have already issued guidelines to our staff. If we are unable to locate the exact unit, we need to communicate with the management office, police, or the owner's corporation. And sometimes we even need to reach out to that particular media through our news officers. I hope that with this procedure, we would be able to know exactly where the fallen window is from. As mentioned by the director, if we want to make the owners accountable, we need to amend the legislature. We can't just rely on the summary offense ordinance, because it would be treated as just some general fallen object cases. We don't have any bureau or department in charge of that. After amending the legislature, I think the buildings department or the bureau would be taking lead of this prosecution. They would be making decisions of referral. I hope that you can be responsible because it will be required by law. Director? Noted. Ms. Khan? For the prosecuting cases, how effective are they in Note 20 and Note 24? The penalty is a fine of $5,000. So how is it being compared with the highest fines or penalty available? Ms. Khan, do you know how long it's needed? We still have one more question after this. This meeting is supposed to be adjourned by 1 p.m. Vice Chair has also indicated he would like to speak. Anyone else? How about we continue the hearing after 2 p.m.? It is already 12:55. We have only 5 minutes left. Vice Chair. If we can finish it within 15 minutes, then we don't have to come back again in the afternoon. Well, I have another appointment by 1 p.m. I have another meeting. Okay, Ms. Khan, you can continue. I will extend the meeting for 15 minutes. I want him to respond to my previous questions because in Note 24, the fine was $5,000. It is falling short from the requirement of the legislature. It is related to the policy. Let me take this question. Yes, Secretary. If there is no reasonable factors given to the non-compliance, the highest fine is $25,000 and imprisonment of 3 months. We seldom sentence them for imprisonment. As Ms. Khan said, you see that it is only being fined for $5,000, so it is falling short from the highest possible fine. We are now suggesting to revise it to a fine of 100,000 Hong Kong dollars and an imprisonment of 3 months. Therefore, we want to step up in deterring people from violating the ordinances. Ms. Khan, my last question about your long-term policy. As mentioned, we have already inspected about 47%, but there are still 54% of them, that is 16,000 odd cases. They are being included. They age 10 years above, but you are still unable to inspect them. What is your current policy? Do you have a target of cases per year? If it is about 500 to 600, then it might take over 20 years for us to inspect all the buildings that fall under the scope. Can we rely on technology? Would it help us in selecting our buildings? How can we do it better? Do we have to wait 20 years? Secretary. This is our policy that we will empower the director of BG to select a high-risk 10 years building for inspections. So it is not a must for us to inspect all the buildings aged 10 years or above. We hope to select the buildings more precisely. And we also want to increase the selections. Technology is surely going to be of help. We need to rely on manpower and following up the cases. So it is already taking up some of our headcounts. If we can rely on technology in the follow-up actions, then we are able to start more new cases, and we can also analyze the fallen window incidents. Such analysis will help us to be more strategic in our future selection. Thank you, Chairman. No further question.
Mr. Porter, I'll be quick. We have another panel at 2:30 and then another Bills Committee meeting at 4:30 p.m., so I will be brief. I want to write on Ms. Corbin Khan's question. Note 24 says there were 4 cases of fallen windows. 3 such cases led to prosecution. Now, the QP for one case was convicted and was fined $5,000. Under Note 20, it says, if this person, this QP, did not personally work on the case and did not provide proper supervision, the fine should be $250,000. And if this QP did not ensure the safety of the windows, the fine would be $1 million and 3 years in imprisonment. I wonder why people would want to become QPs given the heavy penalties. Now, we now have 18,000 QPs in Hong Kong at the moment. So I have a question about the case where there was not enough evidence. Is it a case of not enough details on whether this QP was personally responsible? Sorry, I wonder if you have the details. It wouldn't be fair for me to press this question if you don't have the details. We don't have the details at hand. 4.3 says, you appoint a QP, you have to give notice of appointing the QP in 7 days' time. This is a statutory requirement. This applies to both windows and buildings inspection because the QP will have to sign a document proving that they have been appointed. But now we have streamlined the procedure, so we are waiving this notice. Because in this case, the QP can say they did not take personal responsibility for the supervision. So this requirement that you waived, was it put in place because of a real need? So I wonder if this is a problem in monitoring the work of QPs. Now, in the interest of time, I will be brief. How do you appoint a QP? There are 18,000 QPs in Hong Kong, but when you do appoint a particular QP, so do you wait for the QPs to volunteer, or how does the procedure work? Now, some QPs inspect and repair the windows themselves. Some people only do the inspection without the repairs. So how do we decide when a QP only inspects and when they inspect and repair? Now, we'll take the first question, and then I will let the director take the second question. Now, the point about waiving the notice requirement, that is no cause for concern. That is because the building owner will have to submit documents to the buildings department, whether it's just inspection or inspection plus repair. So we will know who the QP was in the case. We will be able to find the QP. When I responded to Ms. Carmen Khan's question about penalties, I was mentioning the penalties for the building owner. So non-compliance with a statutory notice for windows inspection, I mentioned the fine. Now for QPs, when the QP is responsible for the work and they do a poor job, there are separate penalties. Those penalties are higher because we are talking about professionals. Director. Now, once a QP has the experience, has the qualifications, they can apply to be on this register of QPs, and people can look up this register of QPs on the website of the buildings department. For prescribed inspection, you need a QP. As for the prescribed repair, you will need a registered contractor. The registered contractor can be a registered minor works contractor. And when the QP is also a registered contractor, the QP will be able to inspect and repair. But the QP will have to let the building owner know that they will be doing both, because the building owner has the right to appoint a separate contractor for the repair. So the owner has the flexibility. So we do have the numbers. What's the share of QPs who are also RCs, what's the share of QPs who do not repair? We don't have the figures. Mr. Porter. I hope this does not happen, but I wonder when the same person inspects and repairs, I wonder if that will lead to unnecessary repairs, or whether the same person inspecting and repairing will cut themselves some slack in repairing. Now, when we designed the law, we anticipated such scenarios. We wanted to guard against such cases. So when the same person is a QP and the RC, this person will have to let the owner know and secure the owner's consent before proceeding with the repair. If the owner disagrees, say the owner is worried that the RC will be slacking their work or proceeds with needless repairs, the owner can appoint a separate RC for the repair. So we don't have to worry about needless repairs. Many people are smart consumers, but not every owner is as alert. We don't even have the percentage, we don't have the share. So let me put the question differently. Have we received any complaints about such problems? Deputy Director. I don't have the figures at hand, but we did had people approaching us saying that their QP proposed repairs, and these people wondered whether the repairs were warranted. So we told people they didn't have to replace everything. We encouraged the public to be smart consumers. We gave out pamphlets. You don't have to replace everything on the windows. We focus on the screws and the switches, anything that has a bearing on the safety of windows. Now, some people arrange fitting out or renovation for their windows. They replace everything. But that may not have to do with safety. So we get this message across. Of course, we can also step up the work. So when you review the legislation, can we review the mechanism to ensure we have enough protection for consumers? Given this potential conflict of interest, because the QP is supposed to supervise the RC. Now, someone who gets things wrong may be fined $1 million and 3 years in jail, but there can be abuses. So, I will be brief in my next question. Now, the ordinance says must. The director said it's okay if you adopt a practice across the board, but the ordinance says you must do something. We uphold the rule of law in Hong Kong. So departments as a whole should follow the law. So I want to clarify this point, that strictly speaking, the department is breaching the law. So when can we amend the law? Secretary. We treat that practice as a blanket exemption. But strictly speaking, what we do is not perfectly consistent with the letter of the law. We're not exempting particular cases. We are granting a blanket exemption without compromising this overall procedure of inspection and spot checks. We're already working on the legislative amendment. In the first half of next year, we will table the bill in LegCo. So we won't have to just to get to a legislative exercise just for this point. We will get to this in the amendment bill to be submitted in the first half of next year. Chairman, I can see the problem, but we should not wait. Given how seriously we take the law, We got the amendment done in 1 day for national security. We should be amending the legislation as soon as we can if you see a problem. A society that upholds the rule of law, a government that follows the law, should not tolerate this kind of departure from the law. Any other questions? Mr. Lewis Low. A brief follow-up question. Now, I'm looking at the letter tabled this morning, and that's R84/4/Gen 4. I'm looking at the third annex, and that's the minutes of the 18th meeting of the selection panel. We got an excerpt, but something came to my attention. Among the people who attended the meeting, there were official members. As for the other attendees, those names came with an asterisk, so those people joined via a video link. Was this an option? Was joining virtually an option? Or did we ask people, those non-official members, to join virtually? Deputy Director. Now, we used to hold meetings where everyone attended in person, but then during the COVID years, we got virtual meetings. And then normal life was back. Some members stuck to the virtual option. So we gave these non-official members the option. They could choose to attend in person or via a video link. Mr. Lewis Long. I get it. Things changed during the COVID years. And then even after normal life was brought back, different organizations resumed in-person meetings. I know it's up to the department how they hold their meetings. I just noticed that all non-official members opted to join via a video link. This is an annual meeting. It's once in a year meeting. And then you have another meeting every 6 months. So you have no more than 2 meetings every year, and all non-official members chose to attend virtually. I'm not trying to pass judgment, but I just find that weird. Mr. Long. No other member wishes to speak. Does any other member wish to speak? So all done? Anything to say by way of summary? Chairman, so we held 2 hearings to go through this chapter. At the 2 public hearings, members asked insightful questions. We got replies from the administration. We have yet to receive some replies. I hope the administration can provide those written replies as soon as they can. In this chapter of the audit report, the Director of Audit pointed out many problems. I remember last Friday, I put this question. There were embedded issues. The same problems were raised back in 2020 about MBES. So I hope through this hearing, the administration can learn from the experience. I hope the BD can truly implement the audit recommendations. So that's a brief summary. So I will extend the meeting further by 5 minutes. Any other questions from other members? If not, we thank the administration for attending the meeting, including the BD and the Bureau and the Audit Commission. I also have a brief comment. Now we see outstanding prosecutions from the audit report. Arranging windows inspection also means a lot of work for people, for building owners. There were 700,000 notices that went out. These notices affected the people of the city. Of course, safety matters. We have two separate mechanisms, A and B, depending on the age of the building. Windows break down for two reasons. One, someone broke the windows. People hang heavy clothes or wet clothes on the windows. Or poor installation was the culprit, leading to many defective windows in the housing estate many years ago. So when the windows were installed in the same batch many years ago, and then those windows fell into disrepair en masse. Now, but when it's the case of misuse, people hang heavy clothes on windows, leading to disrepair. And because of that one case leading to mandatory inspection for other windows of the same flat, with that in mind, we have to strike a balance. We want safety, but we also want to avoid needless disruption for other people. So if members have no other questions, so that's it for the public hearing for this chapter. So can the administration please provide the written reply based on the points raised by members? So after we have compiled the report of this committee, we will submit the report to the Legislative Council. So we won't need the 2:30 p.m. meeting, so let's conclude the meeting here. Thank you.